So we're very excited to have our opening keynote speaker, Professor Megan Davis. And as we were thinking through this conference, at the time Meg was the chair of the United Nations Permanent Forum on Indigenous Issues. Had a global role, working tirelessly and fearlessly here in our country as well. And I took it to the board and said, look, if we're going to have an international conference, we need to be able to connect the local with the global. And I thought no better person than Meg to be the opening keynote. So Professor Megan Davis is a Professor of Law and Acting Commissioner of the New South Wales Land and Environment Court, Fellow of the Australian Academy of Law and member of the New South Wales Sentencing Council. As I mentioned, Megan has been the immediate past chair of the UN Permanent Forum on Indigenous Issues and has fulfilled a number of roles in the UN space. Megan's current research is on constitutional design and Indigenous peoples, and is one of the chief investigators of an Australian Research Council project on the impact of extra-legal factors on the sentencing of Indigenous offenders of sexual abuse of Aboriginal women in the Northern Territory. She recently edited a fantastic book on Indigenous perspectives on recognition, along with Marcia Langton, Professor Marcia Langton, who will be joining us as well for the conference. Megan has also previously been a member of the Prime Minister's expert panel on the recognition of Aboriginal and Torres Strait Islander peoples in the Constitution and is currently a member of Referendum Council. And she's probably most famously known for being just a one-eyed Maroons supporter. So Meg, please come.
Someone texted me as I was walking up, break a leg, and those stairs are really steep. So there is a potential here, Rom. Just saying. As an Aboriginal woman, a Cobble woman from southwest Queensland and southeast Queensland, who grew up in Hervey Bay and Eagleby, I would like to pay my respects to the traditional owners of this country and their elders past and present, and acknowledge the really beautiful welcome to country this morning by Aunty Diane Guerin. I'm sorry, I can't see anyone in the audience, so I know that you're out there. Rom, thank you for that generous introduction and happy birthday. Rom has been a dear friend of mine for a very long time. I'd also, of course, like to acknowledge Lowitja. What an amazing speech and opening. I started my legal career as a law cadet in the legal branch of the Aboriginal and Torres Strait Islander Commission in Canberra. And Lowitja was someone I, like many young Aboriginal women, looked up to and admired for her incredible leadership of ATSIC and our people. Political participation of Aboriginal women is a really important thing and has been in my research and was in my PhD, of which Lowitja featured greatly. And for a young Aboriginal girl growing up in Eagleby, it had a huge impact on me to see you on the nightly news and read about you in the newspaper. ATSIC set me up in terms of my professional career as a lawyer, paid for my education, paid for my legal qualifications, gave me the experience at the United Nations in terms of drafting of international law, and gave me an appetite for law reform, which is what I went on to work on, because practicing there, I decided I didn't like practice so much. What I was interested in was how you could reform the Constitution to better improve our public institutions in relation to Aboriginal and Torres Strait Islander people. I'd also like to give a shout out, and again I can't see anyone, but to Willie Littlechild, who is a dear friend of mine. I'm told he's somewhere in the building, and it's been a real honour to serve alongside him at the United Nations. Willie has encouraged a deep love in me for ice hockey, and in particular, an obsession I now have with the machine that cleans the ice after each round. So much so that he presented me formally last year at the United Nations as a gift for chairing with a matchbox size of that machine, which I think is called the Zamboni or something like that, that takes pride of place on my bookshelf. So we're really thrilled that Willie is here to share with us really important insights from Canada in relation to the work of the Truth and Reconciliation Commission, which I think is something that's overlooked in Australia and the subject of discussion tomorrow. I'd also like to acknowledge Ken Wyatt, who I've worked very closely with on constitutional reform, and it's amazing to see him in his current position, but also someone that continues to take an active role in the work of, or active interest in the work of the Referendum Council. And to that end, my final acknowledgement is to Pat Anderson, who could not be here today, but it has been such an incredible opportunity to get to know her and work with her as she is the co-chair of the Referendum Council, serving alongside Mark Liebler. She has been quite extraordinary in the development of a new deliberative process that the Aboriginal members of the Council have developed to take constitutional reform ideas out to communities and, as Lowitja alluded to, actually ask communities themselves to tell us what it is that they want. To that end, my talk is on the history of Aboriginal and Torres Strait Islander advocacy for structural reform. Before I turn to that, I wanted to say a few things, though, about the Lowitja Institute. It's indeed an honour to present today the work of the Institute as one of our leading academic and intellectual institutions in Australia is critical to the development of Aboriginal and Torres Strait Islander law and policy making in Australia. Of course, primarily, the Institute works in Indigenous health research and policy, but it cuts across so many multidisciplinary fields of endeavour as they relate to our mob. For example, as a constitutional lawyer, we welcomed the Lowitja Institute's work on linking constitutional reform to Indigenous health. Why is this work so important? The Institute's contribution to national and global research on Indigenous health is precisely the kind of work that needs to be recognised and funded by the Commonwealth as a commitment to Indigenous participation and law and policy design by Indigenous peoples themselves. I wrote about this recently in the Monthly this year, about the failure of successive governments to listen to the work, the ideas, the research of Aboriginal and Torres Strait Islander peoples and communities. I argued that this failure to listen is partly due to the nation's express abandonment of the right to self-determination as critical to successful policies impacting our mob. The disavowal of self-determination saw the advent of bipartisanship, and we know bipartisanship has been essential for the COAG Closing the Gap agenda, the Council of Australian Governments Closing the Gap agenda. Intuitively, and in addition to that, constitutional reform, intuitively, bipartisanship makes sense. It promotes coherency and continuity, but it does not always sit well in a parliamentary liberal democracy where institutions function on the mediation of disagreement. Important disagreement about the substance and content of laws and policies that should in fact be publicly ventilated and debated. In some ways, bipartisanship has locked our people out of the conversation because those discussions are had about us behind closed doors. Bipartisanship has limited and on occasions excluded Aboriginal and Torres Strait Islander participation in policy development. I wrote that the exclusion of Aboriginal polities from decision-making and the alarming levels of unfreedom that define communities have, however, animated complex and hard-headed proposals for structural reform. This, in a nutshell, is the work of the Lowitja Institute, an institute that is punching above its weight globally on Indigenous health. The Lancet collaboration that Rom referred to at the outset is a shining example of this excellence. It is an example of the exceptional work our mob does on the ground, devising solutions to the problems in our own communities. After all, we know from the right to self-determination who is better to devise these solutions, who knows our communities better than ourselves. So the theme of this international conference is identity, knowledge and strength. And as a United Nations expert serving on the Permanent Forum on Indigenous issues, I am pleased to see in this week's conference that it also explores the Sustainable Development Goals 2030. It's critically important for us to understand the relevance of this United Nations-led framework to our work. Unlike the Millennium Development Goals, the SDGs apply to developed countries like Australia, and they are filled with finely grained goals attuned to many things that are lacking in Australian public institutions and public policy, in particular, the important role that Indigenous peoples can play in democratic decision-making, and equally, the importance of women's participation in democratic practices. On both these measures, Australia fares poorly. 6 years serving on the Permanent Forum and hearing about the many ways in which other UN member states accommodate Indigenous voices in their public institutions, including Parliament, has persuaded me of the need for structural reform. It's quite an incredible thing to sit there at the United Nations and see the trust that other governments in other countries invest in Indigenous peoples to run their own affairs. So the critique of Australia's poor democratic practice as it relates to Aboriginal and Torres Strait Islander communities is the subject of my keynote because it's the subject of the current iteration of constitutional reform in Australia. After discussing what I would speak about with Pat Anderson, we decided it's an opportune time to share with all of you here in this keynote the work of the Aboriginal members of the Referendum Council. I accept that there is constitutional reform fatigue in the community. In 2017, we enter the 10th year of this current reform project, if we were to take our starting point as John Howard's policy to recognise Aboriginal and Torres Strait Islander peoples in the Australian Constitution in the 2007 federal election campaign. If we take as our starting point the report of the Prime Minister's expert panel on the recognition of Aboriginal and Torres Strait Islander peoples in the Australian Constitution, which was handed to the Prime Minister in January 2012, then next year will be half a decade since this has occurred. For those who adopt the 1967 referendum's 10-year campaign as a yardstick for this work, or the work that's required to seek structural reform, then we are well and truly down that path. For those who are in attendance who are not across the Australian developments on constitutional reform, there has been much activity in the past decade aimed at structural reform and Aboriginal and Torres Strait Islander peoples. To some extent, this activity has been aimed at the fundamental question: is this reform about a commemorative plaque in the Constitution, a solemn recognition of a fact, a statement of fact that we were here first and continue to live here, as opposed to another question, whether the reform is in fact structural reform, Is the reform about public power? Will the reform change our lives on the ground? Will this reform give public institutions like the Parliament, our courts, or our communities something to do so that we are active participants in the democratic life of the state, so that we are active participants in designing the laws and policies that impact upon our lives? There has been so much community activism that must be acknowledged that has reshaped where constitutional reform is heading. To say, for us, constitutional acknowledgement, the commemorative plaque in the Constitution, is not enough for us. The creation of the Referendum Council last year by Prime Minister Turnbull is an acceptance of this. And Prime Minister Turnbull has been very supportive of the work of the Council and the dialogues that we're about to roll out, as has the opposition leader. I, like Pat Anderson, as I said from the outset, is a member of that council, and we have decided to go out to the regions and conduct regional dialogues on reform. We are asking the regions to decide what meaningful change is to them. And it's our job to report to the Prime Minister and the opposition leader on what people want. First, we held a series of meetings this year across Australia in 3 locations, Broome, Thursday Island and Melbourne, to explain what we thought the process might be and to ask people whether they thought it was a good idea and whether they would participate in this. Based on the advice of 3 cohorts, traditional owners, Aboriginal organisations and peak bodies, and the Lowitja Institute participated in this, and individual leaders who are active in the area of reform and criticism of the reform, those who are involved in treaty or agreement making around the country. We met with those people and flowing from those conversations have designed the next phase, a deliberative process rather than a consultation process, because we want people to actively participate in the design of what that reform looks like, not to hold ticker box information sessions, but to craft what they believe is the most meaningful path forward. And without traversing the entire history of dispossession and subjugation, one thing is true: we all accept that there's been no significant structural reform, that is to say, redistribution of public power to Aboriginal people in recognition of our unique status as First Peoples. So what we have done as a council, and what I'm going to take you through now in the time remaining, is to retrace that history of advocacy by our leaders, Aboriginal and Torres Strait Islander people, for reform, so we can remind ourselves in the year ahead that this reform is something that we have been arguing for a very long time. So I'm going to play a short clip that I've been working on with Rachel Perkins. We have taken the history of the movement in terms of structural reform and are producing a short film that will be played at each of the dialogues to explain the history of the advocacy. Rachel and I have only got up to 12 minutes, which means that when the clip finishes, I will finish off the modern trajectory of advocacy for reform, and after that I will wrap up. So I'm going to very quickly pick up where Rachel was, but that's really difficult because I don't have her voice. I'll try. To take us to the current situation in terms of the Referendum Council, keeping in mind that time is running out. So the Aboriginal Tent Embassy grew out of the inertia of the Commonwealth post-1967 referendum. So the 1967 referendum gave the power or the competence to the federal parliament to make laws for Aboriginal and Torres Strait Islander people. However, but for 1 or 2 very minor pieces of legislation, it did not use the power after the referendum to achieve or realise the aspirations of Aboriginal and Torres Strait Islander peoples. So Fakatsi went to the Prime Minister only months after the referendum, to ask for the implementation through this new head of power of some aspirations that they had consulted around Australia on that included better civics, recognition of Aboriginal customary law, and some other issues, and the government said no. So the 10 Embassy grew out of that inertia, in addition to the land rights activism that Rachel alludes to. But the 10 Embassy is a really important example of how, if you track Indigenous advocacy for structural reform in Australia, all of the really significant developments for our mob have come through activism or through litigation. During the 10 Embassy demonstrations, we know that the opposition leader at the time, Gough Whitlam, had visited on a number of occasions the Embassy to talk about what was a very comprehensive plan for land rights and sovereignty. That included legal title to land and mining rights, protection of sacred sites, and compensation for lands not returned. What we saw out of this was the formal adoption of self-determination as a principle underpinning policy pertaining to Aboriginal and Torres Strait Islander people at the Commonwealth level. What's important in this issue is the use of this head of power that was provided to the federal parliament in the 1967 referendum to enable it to pass laws that affect Aboriginal and Torres Strait Islander peoples. So the use of that head of power to advance our aspirations. Moving on from that, in this self-determination, some contest that it was a self-determination era, but if I just call it that for purposes of brevity, we see another campaign for structural reform relating to Aboriginal and Torres Strait Islander peoples, and that is the treaty campaign that came out of the National Aboriginal Conference, where at its April 1979 National Conference called for a treaty of commitment to be negotiated between the Commonwealth and the Aboriginal people. What's important in that was that on the 21st of August 1979, in response to the NAC resolution, Prime Minister Malcolm Fraser indicated that the Minister for Aboriginal Affairs was examining the NAC proposal and confirmed his preparedness to discuss the concept of a treaty with the NAC at a mutually convenient time. In 1979, the NAC resolved to adopt the term Makarrata in place of the expression Treaty of Commitment, which is a Yolngu word from northeastern Arnhem Land, sometimes translated as things are all right after a conflict or coming together after a struggle. What's significant about the Makarrata was, many things. It's a very comprehensive document, but it calls for, among other things, recognition or reservation of several seats. So political participation was a really central part of that for Aboriginal people in Commonwealth, state and local governments. So significantly, in terms of that Makarrata framework and the momentum towards that, in 1979, the Minister for Aboriginal Affairs, Fred Chaney, issued a press statement on behalf of the government welcoming the NAC initiatives with respect to the Makarrata and confirming its willingness to join any discussions as the proposal moves forward. In addition to this, in 1981, we see the Senate Standing Committee on Constitutional and Legal Affairs conduct an inquiry into the feasibility of a Makarrata between the Commonwealth and Aboriginal people. And in its 1983 report, the Senate Standing Committee on Constitutional and Legal Affairs recommends a constitutional amendment along the lines of Section 105A in the Constitution, which inserted into the Commonwealth, into the Constitution in 1929, the power for the Commonwealth to enter into financial agreements with the states. The idea being that you could have a like provision in the Constitution for the purposes of agreement making with Aboriginal and Torres Strait Islander people. In 1988, we have the bicentenary, which is 200 years since the invasion. The bicentenary calls for, the Barunga Statement calls for many things, but in particular control over our own affairs, self-determination and self-management. And importantly, it calls for a national elected Aboriginal and Islander organisation to oversee Aboriginal and Torres Strait Islander affairs, a national system of land rights, and calls upon the Commonwealth to enter into a treaty. So what we know about that call for national land rights and a treaty is that Prime Minister Bob Hawke does not deliver on the promise of a treaty or national land rights. In its place, he creates a statutory process for reconciliation. This is interesting and has been discussed at the Permanent Forum on Indigenous Issues at the UN in relation to Australia's curious reconciliation process that wasn't based on the twin pillars of truth and justice, which is the foundation of all reconciliation movements globally. Rather, it was created by statute as a process to replace a treaty and land rights, national land rights process. We have the High Court hand down the Mabo decision in 1992, Mabo was a culmination of a 10-year struggle of the Meriam people seeking rights to the use and enjoyment of their traditional lands in the Torres Strait. The action was commenced by 5 Murray Islanders, including Eddie Mabo, and the question asked by the Murray Islanders was whether, on acquiring sovereignty, the Crown had gained complete ownership of the land or whether it was burdened by prior Aboriginal title. The court rejected the idea that Australia was terra nullius or no man's land at the time of the British arrival, and it held as a result that the pre-existing native title rights of Indigenous peoples continued to exist. In terms of structural reform, what's really significant here for us is that following the Mabo decision, Keating negotiated a 3-part response to address the dispossession of Aboriginal and Torres Strait Islander peoples, of which Lowitja led. There were the Native Title Act, 1993, the Indigenous Land Fund, Land Corporation, and a social justice package to compensate Indigenous peoples unable to access native title. An ATSIC committee led by Charles Perkins and the Australian Human Rights Commission's Aboriginal and Torres Strait Islander Social Justice Commissioner, Mick Dodson, led the consultations with Aboriginal and Torres Strait Islander people around Australia on what is an appropriate social justice response to Mabo, and they published and submitted to the Prime Minister a very comprehensive report entitled Recognition, Rights and Reform. So that reaffirmed Aboriginal aspirations in light of Mabo. It included suggestions that the Federal Parliament use the power gained in 1967 to initiate major institutional and structural reform such as regional self-government, regional agreements, and the negotiation of a treaty or a comparable document. So that's the report there. It also included a recommendation that the chairperson of ATSIC be granted observer status in the Parliament and the ability to speak to both houses on bills affecting Indigenous interests. It also called for further investigation into Indigenous reserved parliamentary seats. The report said that Indigenous Australians are particularly susceptible to shifts in government policies and funding priorities because of powerlessness. Political participation would foster greater equity in the provision of services and accountability by governments. It would enable articulation of Indigenous policy perspectives, broader participation in policy development, and promote a wider understanding of Indigenous issues in the broader community. What, of course, is significant for us on this journey in relation to reform, advocacy for reform, was that element, that key element, the social justice package arising from the Mabo decision, has never been implemented in Australia. Next, which is really, I would argue, as a lawyer, probably the part of the genesis for the constitutional reform movement today, was that our constitutional protection shrinks. John Howard came to power, and one of his government's first acts when it came to power in 1996 was to shepherd legislation through Parliament relying on the race's power, so Section 5126, amended in 1967, to prevent the Ngarrindjeri women in South Australia from invoking the Aboriginal and Torres Strait Islander Heritage Protection Act to stop the construction of a bridge over an area where they engaged in secret women's business. This act, the Hindmarsh Island Bridge Act, restricted the operation of the Heritage Protection Act, so it applied everywhere in Australia except for the Hindmarsh Island Bridge area. This legislation was challenged by the Ngarrindjeri women in the High Court on the basis that the race's power, as it was amended in 1967, cannot be used in an adverse or detrimental manner by the Commonwealth. The Commonwealth argued in the High Court that there are no limits on that head of power so long as the law imposed a consequence based on race. So effectively, the Commonwealth argued that it could use the race's power to pass discriminatory laws. Following on from the 1998 decision in the High Court, we see Australia's movement towards a republic, and we have a republic referendum, a referendum to amend the Constitution. Included in that is a proposal for a preamble which would recognise many aspects of Australian society, but in particular Aboriginal and Torres Strait Islander peoples. It is well known that ATSIC leaders and other Aboriginal leaders objected to the language that was used in the preamble. So it was resoundingly criticised. What's significant for us there, however, is that the government proceeded anyway with the language that was in the preamble. So we see this really comprehensive report emerge from the Council for Aboriginal Reconciliation after their decade-long work on reconciliation, which again calls for really substantial structural reform, including constitutional reform and recognition. So it's partly from the social justice package and CAR where this notion of an acknowledgement, the plaque that I referred to, emerges, but that plaque, the symbolic recognition, is only important if it's connected to the really substantive ideas for constitutional reform. So you can see at the bottom of this slide, CAR recommends that a referendum is prepared to recognise Aboriginal and Torres Strait Islander people in a new preamble, remove Section 25 of the Constitution, which contemplates the states passing discriminatory voting laws, but introduce a new section making it unlawful to adversely discriminate against any people on the grounds of race. And for those of you conversant in the contemporary drafting for reform, you would know that Section 116A reflects this sentiment. We, at this time, or following on from this time, ATSIC has a central policy for the creation or for the development of a process for a treaty. It conducts community consultations around Australia, but is formally abolished in 2005, and that momentum towards a treaty that began with the NAC and the Makarrata comes to a halt. I should delete that because he hates those photos in that slide. We have some advocacy from Noel Pearson to John Howard in 2007, where he writes to him before the election saying you need to commit to a new Indigenous representative body and also this Rights and Responsibilities Commission, which will be an interface to oversee agreement making around the country for our mob. In 2008, we see a Yolngu petition handed to Kevin Rudd. So obviously Kevin Rudd won the Kevin 07 election, and he was handed this petition, which again calls, as you will see at the bottom, for really fundamental recognition of rights and that the Parliament start the process of recognition through serious constitutional reform. Kevin is, of course, kicked out, so Julia creates this new entity called the Expert Panel on the Recognition of Aboriginal and Torres Strait Islander Peoples in the Constitution, who go back through that advocacy we've been talking about and settle on these 5 recommendations for reform: Section 25, the race power, a new statement of recognition in a head of power, a clause recognising Indigenous languages, which wasn't very popular because it recognised English as the official language, and the insertion of a racial non-discrimination clause. We have a difficult time post-expert panel because of this word recognition. And for any of our North American friends, they would know that the word recognition is a contested legal and political concept, and it's fraught with a lot of danger because its plain English dictionary meaning is acknowledgement. And what Aboriginal and Torres Strait Islander people have been arguing for, as you would have seen in the video and this presentation, is very substantive forms of structural reform. Then we have post-expert panel, and Ken is of course here, the Joint Select Committee on Constitutional Recognition that does a valiant job of trying to make sense of the expert panel's recommendations. It hands down 3 reports, an interim, a progress and a final report, and that's essentially where the drafting anyway sits. In addition to that, to Ken's committee, the Cape York Institute resubmits this idea for a voice to the federal parliament. So a constitutional amendment which creates a body that would contribute to laws and policies in the federal parliament that affect Aboriginal and Torres Strait Islander people, and beneath that would sit a representative structure that includes the capacity for mob around the country to enter into agreement making with the state and with each other. And that's where we sit, and with my one minute, Rom, I will just wrap up. So it hasn't been an easy process for anyone since the expert panel. For some time, a lot of Aboriginal and Torres Strait Islander people have felt that all of the conversation surrounding reform suggests that only symbolic reform was on the table and not the kind of structural reform that we know we need to make a difference on the ground. In 2015, we met with the Prime Minister at the time, Tony Abbott, and the opposition leader, Bill Shorten. Following this meeting, the National Congress of Australia's First Peoples and the leaders who attended drew a line in the sand and said, the deletion of Section 25, the amendment of the race power or its replacement, and an acknowledgement, so the plaque I'm referring to, that is not enough for us. That is the line in the sand. After the Kirribilli meeting, we requested another meeting with Tony Abbott, and there we secured Aboriginal-led and Aboriginal-designed deliberative process, one that's not consultation, but it's deliberative. Malcolm Turnbull, who then became our Prime Minister, set up the Referendum Council, and the Council has been conducting this work. The First Nation dialogues will be happening in 2017. The last comments that I would make arising out of all of this is that this is law reform, and law reform is not easy. We come up against, in conversations about constitutional reform, continual tension between the pragmatists and the political realists and the law reformers who are inherently dreamers. Law reform does require you to imagine that the world, that Australia, could be a different place. And to do that exercise, to ask communities to imagine that Australia can be a different place, requires them, often very vulnerable communities, to suspend disbelief about the way politics deals with Aboriginal and Torres Strait Islander peoples. But for at least part of the deliberations, we do ask mob to separate out their political thinking and their questions about viability and their questions about political reality, to spend some time just dreaming what meaningful change would look like for them on the ground, what meaningful change would mean for their Jarjums and their grandchildren. And then once the dialogues elect Aboriginal representatives to go to Uluru, it is there that the political pragmatism and the feasibility of all of these measures and the viability will come into play. But to borrow from Lowitja and Ujuru, let's use this opportunity to take our place at the heart of the nation and build that glad tomorrow. Thank you.